Quote, in your opinion, is this executive order constitutional? He asked. Said Shoemate, it absolutely is. Frankly, I have difficulty understanding how a member of the bar could state unequivocally that this is a constitutional order, Coughenour said. It just boggles my mind. Welcome to Law and Chaos. Trump has now been in office for less than a week, and he's already working hard to erase the past 4 years. Then he can get to his real job, disappearing 50 years of civil rights law. We're diving into those vile executive orders today and how we can fight them. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torrez. Andrew, how are you?
Hi, Liz. You know, today may be the most. We've got a lot to cover, so let's get after it. Ever? I'd like, how are you holding up?
It's been a wild one. Yeah, we're 4 days into the Trump presidency, and I gotta say, it's worse than I thought it would be.
Yeah.
And I was prepared for it to be bad.
Yeah, I mean, look, beginning with pardoning all of the January 6th criminals on day one was pretty gross. Although, you know, the executive orders attempting to undo the last 50 years of civil rights law were a bit more consequential.
Yeah, that's why we're going to spend most of the day talking about those executive orders, or two of them anyway. It's going to be an ongoing project. We'll try to get experts on to address specific topics. For Tuesday's show, we'll have a guest on to discuss the order declaring that actually the power of the purse belongs to the president.
Yeah, spoiler, It does not.
Yeah, no. For today, we're going to cover the anti-trans and birthright citizenship orders. But first, docket alerts. Dun, dun. We'll get the bumper. We're still working on that. Anyway, let's start with some good news, which is that the North Carolina Supreme Court got one step closer to allowing incumbent Justice Allison Riggs to hold on to her seat, dismissing much of her Republican challenger Jefferson Griffin's effort to toss out 60,000 votes for some bullshit clerical errors, in hopes that it would get him over the threshold to overcome her 734 vote margin of victory.
There's so much here, but can you imagine having to be Justice Riggs to sit on that court where all of your colleagues are trying to unseat you like this? I mean, yeah.
Unbelievable, yeah. Anyway, the High Court decided not to fool with the 60,000 vote challenge after all. But in the meantime, Griffin filed another case, or a couple of cases. These aim to throw out overseas and military ballots, but only in 4 heavily Democratic counties. The High Court is letting that nonsense sort of work its way through the system and hasn't yet certified Riggs' victory. Those are in lower court challenges.
Yeah, in the run-up to the 2024 presidential election, we talked a lot about Uokava ballots. And, I just want to note here that ProPublica revealed that, of course, Griffin himself cast Uokava ballots when he deployed with the North Carolina Army National Guard. But, let's concentrate on the good news where we can find it. I mean, it does seem like this race is finally coming to an end.
Yeah. So, yay. And also, that's enough good news for us.
Oh, God.
Moving on. As expected, Judge Eileen Cannon enjoined the release to Congress of Volume 2 of Special Counsel Jack Smith's report. That's the volume which describes the stolen documents case.
I wish I could say I was surprised. Hacks get a hack, But at last Friday's hearing, she signaled pretty strongly that she intended to do it to, protect the integrity of the charges against Trump's henchmen Walt Nauta and Carlos de Oliveira.
Yeah. Did you notice that Nauta is in the background of a lot of the pictures of Trump that are published lately? He's still Trump's body man. I mean, look, I guess the only thing that surprised me here is that Trump has not already moved to pardon Nauta and de Oliveira or to drop the cases against them for obstruction. Remember, those were Trump's henchmen who lied about hiding the boxes of documents, the stolen documents, and then tried to delete the security camera footage of them doing it.
Yeah, I am kind of wondering procedurally how the Department of Justice is going to handle that one, right? Because remember, this case is on appeal to the 11th Circuit after Judge Cannon dismissed the entire thing outright on the theory that, special counsels were illegal. But if they preemptively shut it down, I don't know if we're going to be in a Munsingware situation, if the ruling stands, and then they they would be stuck with that crazy ad hoc precedent floating around out there that would interfere with any special counsels, that Donald Trump wants to appoint. They're planning to do all of these revenge prosecutions, and it sure would be convenient to be able to appoint, I don't know, spitballing Sidney Powell or, okay, more realistically, Mike Davis as special counsel to,
Oh, my God. You guys are going to have to Google Mike Davis. We don't have time for it here. But Mike Davis would be an absolute star chamber villain as a prosecutor.
Yeah.
But I would agree with you. I have no idea what they'll do here with regard to that precedent that's floating around out there, courtesy of Trump's favorite judge. I would note, however, that our buddy Jose Pagliari at the news site Notice called Cannon out on a blatant lie in her order. She wrote, "Never before has the Department of Justice, prior to the conclusion of criminal proceedings against a defendant and absent a litigation-specific reason as appropriate in the case itself, sought to disclose outside the department a report prepared by a special counsel containing substantive and voluminous case information until now." But, as Jose points out, Robert Mueller released his investigative conclusions while the case against Roger Stone was still pending and while the government was still trying to seize Paul Manafort's assets in court.
Yeah, the Mueller report had an entire section on cases that it referred out that were still live. I mean, most of it was redacted, but most of this would have been redacted. It's so pretextual. But look, Trump eventually pardoned both Stone and Manafort, so
yeah.
I'm sure he's going to take care of these low-level flunkies soon enough. Let's talk for a minute about the Blake Lively, Justin Baldoni dumpster fire litigation. I mean, Liz, I know you wrote about this today.
Yeah, it's interesting. I can't tell if Baldoni's lawyer is just like not from around here and that's why he's being such a maniac, or maybe these guys just don't care what happens in court and the only win for them is like in Reddit forums or whatever. I mean, from a legal perspective, it seems like the stuff they're doing is bound to blow up in their faces in the actual court case. But then I talk to my kids and they seem to think that Baldoni is winning the war of public opinion.
Really?
So, yeah, they do. So briefly, Lively and Baldoni made a movie called It Ends With Us. Lively claims that she was sexually harassed on the set of the movie by Baldoni, who co-starred in and directed it, and also by his business partner and producer, Jamie Heath. Lively filed suit on New Year's Eve in New York federal court against both of them. Baldoni sued her and her husband, Ryan Reynolds, for civil extortion and defamation on January 16th. It's a mess. You want to explain the shenanigans with the process server since you have all this civil litigation experience?
Yeah, I will. When Lively filed her suit, her lawyers at Wilkie Farr asked Baldoni's lawyer, Brian Friedman, the California media lawyer guy, to accept service for the multiple defendants that he represents. And according to the correspondence on file with Judge Lyman, Friedman just ignored that request and made Lively go to the trouble of hiring a process server and serving all of the defendants personally, which they did. I mean, look, you can do that. I mean, Rudy Giuliani certainly does it a lot, but I mean, it's a dick move, right? Like, you're a lawyer, act right. I always execute the waiver. Like, it's just, that's just how federal practice works. But then Baldoni files his suit and Lively's lawyers say, hey, look, like, we'd like to avoid the whole service of process thing. Like, just we'll execute the waivers. We'll accept service from you, Mr. Friedman, the lawyer, on behalf of your client. And they execute the form statement of waiver of service, which, okay, to be fair, the boilerplate does say, I have received your request to waive service of a summons in this action, along with a copy of the complaint. And look, like, I probably signed 100 of these, hundreds. It would not have occurred to the lawyers. I don't think it occurred to anyone that a plaintiff would insist upon executing via personal service, right? Like, you got to pay more money, you got to hire a processor. It's just nonsense. Instead of emailing the document to the lawyer, which is just, it's what you do in these situations. So, and again, Friedman goes radio silent via email. In fact, he sends a process server to chase down Lively and Reynolds and their agents. And the server apparently tracked a young woman home at night, scared, one of their staff by pursuing her in his car to the point where she filed a police report. Like, why be like this, right? I do want to say this. This does not help you, right? Like, service of process is one of these 13th century Saxony doctrine. Like, it's just a box you have to check. The reason we've gone to the waiver system in the federal rules is because it's archaic. There's no legal advantage to doing this. There was only harassment.
Right.
So anyway, the relevant rule is Rule 4D of the Federal Rules of Civil Procedure. It says a defendant who, before being served with process, timely returns a waiver need not serve an answer to the complaint until 60 days after the request was sent. So in English, executing the waiver like a normal person buys you an additional 30 days if you're an in-state defendant to respond to a complaint. Baldoni refused to execute the waiver, but now he wants the 60 days as well. And he's accusing Lively of falsely engineering an extension of time until March 20th, 2025 to respond to his complaint, but now refusing to consent to the same deadline for the Wayfarer parties. Those are the Baldoni parties that Friedman represents, even though doing so is in the interest of justice and efficiency in cases that are not only related, but likely will be consolidated.
Right. I mean, he might have actually a point there. Judge Lyman did put out a show cause order today ordering the parties to explain why these two cases with, the same two parties, more or less, should not be consolidated.
Yeah, I mean, he could have filed it as a counterclaim. But
yes, he could. He chose not to, right? And now he's saying, well, these cases are going to be consolidated. Well, my dude, right? But anyway, before we leave this relatively low-stakes dispute, at least as compared to, everything else we've got to talk about today, can I just say, this case is less than a month old, and the lawyers are already accusing each other of gross misconduct. This is going to be such a withering inferno.
Withering Inferno is my new favorite disaster movie.
Anyway. It's my Styx cover band. Anyway, basically, Lively's lawyers say that Friedman, who is a California lawyer who pro-hocked in here to this New York case, is violating, well, a bunch of things, but among them, California's rules of professional conduct by making false statements about the case, to which Friedman is saying, what, us? We never said anything bad about Lively until after she attacked us. All we did was respond to media inquiries. And of course, there's all this text about meetings that Baldoni and his publicists had with journalists and such that took place before the movie even came out, right? Preemptively. That's the gravamen of this complaint, right? That they slimed her in case she came out and accused him of sexual harassment publicly. Okay. They say that Friedman, the lawyer, is defaming Lively by repeating the false claims on every media platform that will have him, since he's been in this media blitz shit-talking her since before the case was filed. They say that he violated New York's rules of professional conduct by making statements that will prejudice the case and poison the jury pool. And they say that Justice Baldoni violated his contractual agreement not to retaliate against Lively for lodging her harassment claim. Friedman, as Baldoni's agent, is continuing that violation with his public statements, that Friedman is essentially violating the anti-retaliation clause of their contract on Baldoni's behalf.
Yeah, and look, Friedman, for everything else, is an experienced media lawyer, right? Like, that's what he does. He represents Hollywood types and is used to dealing with the press. But the East Coast is not the West Coast. California in particular is, in a very real sense, sui generis, right? So I don't think those antics are going to play well with Judge Louis Leiber, right? The judge who had the Rudy Giuliani debacle, right? But we'll see. Okay. That's it for Docket Alerts. Let's get to an ad break, unless you are a subscriber at any level over at patreon.com/lawandchaospod or on our Substack at lawandchaospod.com, in which case you will get a breakdown of the latest back and forth in the Alex Jones case. And we know you can't wait for that. And we're back. Okay, for our main story, Donald Trump came out of the gate swinging. He issued 26 executive orders on day one of his presidency. That's not just the most. Let me put this into context. Second place is Joe Biden with 9 executive orders on day one. Third place is Barack Obama with 2. Fourth place is Bill Clinton and Donald Trump's first term with 1. And fifth place is a 40-way tie with everybody else with 0, right? So this is unprecedented.
Yeah, I'm old enough to remember when Republicans said that Barack Obama's executive orders were a gross abuse of power. It was a sign of the imperial presidency and not acceptable.
Yeah, well, we're the same age. So look,
no, we're not.
the only way that you come out with 26 EOs on day one is that this work was done in November, right? Because procedurally, what Donald Trump did, the orders that he issued, look like standard executive orders, right? They follow the form and language of what real presidents have done. The content is batshit, of course, but competent lawyers have been drafting these for more than 2 months, right, since the election.
For sure. They've been doing it for a long time. This is straight out of the Project 2025 playbook. I mean, this is not like the last time when Steve Bannon and Steve Miller were just like scribbling nonsense on a cocktail napkin and having Trump sign it. Well, with the exception of the weaponization of government executive order, which promises to like investigate the investigators and prepare a report on all the things that were done in violation of the executive order, which just this minute came into effect. That one was definitely written in Crayola. But the other ones are at least mostly cogent. A lot of it is facially illegal, but it's not crazy. It's not like Alina Habba level nonsense, although I think she's in the White House in some capacity. Anyway, this time around, Trump is staffed up with a whole bunch of John Eastmans. These are guys who are willing to not only push the envelope with their legal reasoning, but kind of argue it in court as if it's real law, not just FedSoc, intellectual wankery.
Well, you push my Eastman button. I mean, remember, during the January 6th attack on the Capitol, John Eastman was engaged in an email argument with Vice President Mike Pence's lawyer, Greg Jacob. And Jacob, essentially wrote back and was like, John, this is not some academic argument at a cocktail party, right? Like, you've sold these people and the president a bill of goods by pretending that the law says something it clearly doesn't. And thanks to your bullshit, the Capitol is now under siege. And, and that was great. But now Trump is surrounded by people who are willing to say that the law says whatever crackpot shit he wants it to say. And the facts, too. I mean, look, we are well past Bill Barr, who got fired because he did what Trump told him to do and investigated the fraud claims in Georgia and then made the mistake of giving Trump his honest assessment, which was there was none. The people now in the White House will do and say any crazy thing. You've already got Donald Trump's personal lawyer, Emile Beauvais. He is now the number 3 at the Department of Justice. He's sending out letters that say local law enforcement officials are obstructing justice if they don't obey federal orders to hand over undocumented immigrants. And those are not legal orders, right? That it's just blatantly untrue, thanks to a long line of cases that involve the anti-commandeering doctrine under the 10th Amendment. The federal government can't just assume control of state law enforcement.
Yeah, and it's already coming around to bite them with respect to birthright citizenship. But okay, these are real-looking executive orders, so each one of them has 2 aspects. The first section is non-binding advice and purpose statements. They're the most inflammatory part, and that's the part that gets the most attention. But they're mostly just a place for Trump to rant and whatever, who cares? It's the second part that we need to look at, because those are the instructions to the executive branch agencies to develop policies and promulgate rules to carry out whatever the rant is. And some of those instructions are wildly illegal, and they're already being challenged in courts. Some of it, however, is going to pass legal muster because the president really does have a lot of power.
Yeah, so let's talk about some of the specifics here. And we might as well start with the ugliest, which is Trump's executive order entitled Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government.
Oh, God.
Yeah. This executive order purports to do 3 things. Number 1, to repeal all of the Biden administration's executive orders promoting gender equality. Number 2, to instruct various executive branches to start discriminating against trans people. And number 3, to declare various interpretive and policy positions. And some of this, as you pointed out, Liz, is probably legal. Some of it is definitely not. And a lot of it is in a gray area, unfortunately.
Yeah, so let's talk about the first category, because that's not a gray area. Trump absolutely does have the power to rescind the Biden administration's executive orders on gender equality or anything else. And those Biden orders included Executive Order 13988, which offered guidance to executive branch agencies on how to avoid discrimination on the basis of gender identity. Also rescinded is Executive Order 14004, which allows all Americans to serve in the military regardless of gender or gender identity, explicitly including cisgender women and transgender individuals, and repealed Executive Order 14020, which established the White House Gender Council. So let's be clear about what that means. At a minimum, we're talking about a return to the first Trump administration's policies, which effectively kicked trans people out of the military or forced them to detransition. On March 23rd, 2018, during the first Trump administration, Secretary of Defense Jim Mattis sent a 48-page memorandum that essentially said, 1, trans people with a history or diagnosis of gender dysphoria are disqualified from service except in certain limited circumstances. 2, trans people who require or have undergone gender transition are disqualified from service. And 3, trans persons without a history or diagnosis of gender dysphoria may serve in their biological sex.
Yeah, that's horrible. And, it just reminds me, Jim Mattis is on the list of people with Mike Pence, Jeff Sessions, Bill Barr, John Bolton, countless others who are absolute craven, monstrous assholes. And yet they've been deemed insufficiently loyal to be in a second Trump administration. I mean, Trump actually revoked Bolton's security detail this weekend, and Mike Pompeo's too. Mike Pompeo, who thinks the rapture is coming next Tuesday, right? Both of them were, you're laughing, but it's true. Like, both of them were the subject of an Iranian assassination plot because they were directly involved with planning and carrying out the assassination of Qasem Soleimani.
Right. I think you mean targeted killing. But good luck, Marco Rubio.
Oh, little Marco. I mean, he could show up to work in the Senate. Yeah, I'm sure he's going to be on the job all the time at state. Anyway, okay. The second thing that this executive order does is affirmatively instruct various executive branch agencies as to how to treat trans people, and badly, right? And as you said, Liz, at one level of resolution, this is within the president's power because he's the head of the executive branch, so he can tell subordinate agencies what to do. I mean, he cannot tell them to violate the law, although he's damn sure going to try.
Yeah. In broad outline, Trump wants every executive branch agency to comport with anti-discrimination laws such that it is the policy of the United States to recognize two sexes, male and female. These sexes are not changeable and are grounded in fundamental and incontrovertible reality. Under my direction, the executive branch will enforce all sex-protective laws to promote this reality, and the following definitions shall govern all executive interpretation of and application of federal law and administrative policy. And then there are a whole bunch of Orwellian redefinitions of basic terms like sex shall refer to an individual's immutable biological classification as either male or female, and sex is not a synonym for and does not include the concept of gender identity, which is all straight out of Project 2025. And here's where the legal battle is going to be waged, because this executive order says point blank, we will not protect individuals on the basis of gender identity from discrimination in any context, and in at least one context that 100% violates the law.
Yeah, that's the 2020 decision by the Supreme Court in Bostock versus Clayton County that held that Title VII of the Civil Rights Act of 1964, prohibiting employment discrimination on the basis of sex, also prohibited discrimination on the basis of sexual orientation and gender identity. And I want to be pellucidly clear here, right? These cases got to the Supreme Court. They were consolidated across multiple circuits and heard where the undisputed facts were that the employer wanted to fire an employee just because they were trans or gay. That's the right that these employers were fighting for all the way up to the Supreme Court. And it is the right, and you can hear the air quotes, that Donald Trump wants to restore to make America great again.
Mm-hmm.
And the Bostock opinion, written by Justice Neil Gorsuch, said, no, you can't do that. And his opinion was a matter of pretty straightforward logic, right? He reasoned that if you as an employer would fire someone who was assigned male at birth, but identifies and presents as female now, but you wouldn't fire someone assigned female at birth who did the same thing, that's pretty obviously discrimination on the basis of sex, however you define sex. And you will not hear me say this a lot, but Justice Gorsuch was right.
Yeah, let's quote this opinion directly. He says, when an employer fires an employee for being homosexual or transgender, it necessarily and intentionally discriminates against that individual in part because of sex. By discriminating against transgender persons, the employer unavoidably discriminates against persons with one sex identified at birth and another today.
Yeah, and Gorsuch wasn't writing on a blank slate here, right? There's a long line of sex discrimination cases, a lot from the 1970s and 1980s, where employers fired women who didn't dress feminine enough, and they tried this same kind of argument, right? Like the employers went into court and they said, "Look, we're willing to hire women. We're just enforcing dress codes," and the courts saw through that bullshit, right? They uniformly rejected those dumb arguments. They said, look, if you're firing women who wear pants and refuse to wear lipstick, but you're not firing men who wear pants and refuse to wear lipstick, that's discrimination on the basis of sex. End of.
Right. And if you're firing a woman who is assigned male at birth, you're firing her for being the wrong kind of woman, which is also discrimination because of sex. And that's against the law. Although I don't think anyone's under the impression that this Supreme Court is going to be receptive to arguments that protect trans and gender nonconforming people in any other context, assuming that Bostock still holds. We listened to the oral arguments in U.S. v. Skrmetti, which was the challenge to Tennessee's law prohibiting gender-affirming care for minors. We will link to our write-up in the show notes. The court's conservatives are pretty clearly interested in cabining the Bostock ruling to the employment context under Title VII and pretending that it's because of sex ruling doesn't carry over anywhere else. So Justice Alito brushed that aside as, quote, particular language in a particular statute, not something that could be generalized as protection for sexual minorities in a non-employment context like school or medical care or whatever. Notably, Gorsuch himself did not say a single word during the entire 2+ hours that Skrmetti was argued. Not a
that
single,
could be a first for him.
not a single condescending hypothetical. And so it seems pretty clear that they are going to uphold the Tennessee law and rule that Bostock only applies to employment discrimination. But Bostock will still be good law. You still won't be able to discriminate against gay and trans people in employment. And people who, are seeking civil rights protection, who are gay and transgender and being discriminated against in an employment context will still be entitled to civil rights protections in, say, the EEOC and other government agencies.
Yeah, although Trump has issued an executive order suspending all operations of the Civil
lies
Rights
the problem,
Division.
Right?
Yeah, exactly right. But look, Donald Trump cannot effectively overrule Bostock by executive order, right? Not even with the aid of a right-wing judiciary. And if you're asking, and I know our listeners are really skeptical. They're like, the Supreme Court's really terrible. Here's how you can know that this is not just two podcasters telling you that the courts are, because various coat factory law firms have been paid large sums of money to issue guidance to their multinational, multi-billion-dollar corporate clients as to whether Bostock is still good law in light of the Trump EO. So I'm going to read from Foley and Lardner's because I happen to have a copy. Foley and Lardner is a law firm that represents Major League Baseball, the NFL, FIFA, Hitachi, T-Mobile, Bristol-Myers Squibb, and Harley Davidson. So, not exactly a gaggle of wokeness. I mean, they do also represent Harvard University. Maybe that undercuts it a little bit. But right, here's what Foley and Lardner said to the captains of industry about whether you could rely on Trump's executive order and start firing all the trans people. They said, quote, many of these now revoked executive orders involve equal opportunity for individuals based on race, gender, gender identity, and sexual orientation. While these orders have been revoked, both state and federal laws continue to prohibit discrimination on the basis of these characteristics. In fact, the United States Supreme Court in 2020 recognized that Title VII protects employees from discrimination on the basis of sexual orientation and gender identity, and then there's the citation to Bostock. As the Supreme Court specifically stated, the statute's message for our cases is equally simple and momentous. An individual's homosexuality or transgender status is not relevant to employment decisions. That's because it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. End of quote. Therefore, this is still Foley's advice. Employers should continue to enforce their policies prohibiting discrimination, including in accord with the Bostock decision. This is, of course, a rapidly evolving area of law, and we will continue to monitor and keep our readers updated.
Yeah. So, okay. I have a whole bunch of thoughts about this. But first of all, as I recollect, during the Biden administration, there were all of these judges, particularly like Judge Matthew Kaczmarek and
Mm-hmm.
a bunch of judges in the Fifth and the 11th Circuit who, trial court judges issued nationwide injunctions on enforcement of just this kind of like the opposite version, like the Biden administration's efforts to ensure non-discrimination in, say, the education context, which clearly this Trump order is intended to do, right? The Trump order revoking it and saying, now we are doing discrimination. What do you think is the likelihood that these laws will face to some same sort of nationwide injunctions?
So, in some sense, this is a heads I win, tails you lose for the obstruct government at all costs movement, right? Because, look, we are complaining about Trump's 26 executive orders. There's a reason that Biden issued 9 and Obama 2, right? Like, because now that Republicans have broken the legislature, ruling, via executive branch orders is kind of what we can do when you elect a president now. So, yeah, these are all going to be challenged. They're all going to go to court. And I certainly am rooting for the courts to issue injunctions, but I'm really worried that, we're going to enter a point where virtually nothing that anybody wants to accomplish as president can get done. And that doesn't bode well.
Yeah, and I guess my second thought, I mean, we'll get into kind of the nuts and bolts in the instructive part of this order.
Mm-hmm.
But my thought is, we're not going to talk about the anti-DEI, the anti-woke orders, but this, like the anti-DEI orders, is clearly sort of intended to push out from the federal government policies onto everybody else, right? So
Right.
In the Biden administration, there were executive orders and there were regulations which said the national government will sort of cut education funding to schools which don't treat trans kids properly. And I worry that what we're looking at here is the federal government trying to push out exactly those same policies by saying, we're going to cut federal funding if you have non-gender discriminatory bathrooms, if you have non-gender, and I think that's what's going to happen. So, as we talked about, we touched on briefly, many of the government departments here are shut down, right? That Trump has shut down the Civil Rights Division and Trump has shut down NIH, and that the reporting is that he's done those things so that he can rejigger all of the policies and the contracts to say, we won't work with you if you have any DEI at all. And that because the federal government is the biggest employer, is the biggest contractor in the country, it will by fiat sort of force every company and educational institution in the country to get rid of, diversity, equity, training. It will force them to get rid of, pronouns functionally is what they're going to try and do here. I think that this is very clearly what the aim is. I don't know whether it'll work because of Bostock. I don't, but that's the plan.
2 quick thoughts. I mean, number one, again, I think your read on Skrmetti is correct, that Bostock is going to be cabined to hiring and firing on the basis of gender identity, and it's not going to extend into any other context. Mm-hmm. And number 2, right, you're absolutely correct with the federal government as a driver to the private sector because of government contracts. And I'm thinking about how
and states, right? The states are going to, right? Because it'll deny federal funding to states if their schools don't have segregated bathrooms, right? Sex segregated bathrooms.
That is exactly right. And so I'm thinking about it. Yes, there are going to be victories in red states that do exactly that. But I'm also thinking about training materials and the kinds of things that typically hit a lowest common denominator, because if you are a for-profit company and you want to make a training manual, you want it to be able to be sold in all 50 states. Mm-hmm. And one of the blueprints for this was how creationists targeted school boards in Texas, right? Knowing that they could do so to say, hey, you better not mention evolution. And then a bunch of major textbook publishers conformed their policies to Texas because, they didn't want to have to sell Principles of Biology Texas edition and Principles of Biology every other edition. You just kind of do the thing that lets you get sold in all 50 states. And there's so many ways that this is going to be insidious. It's a really good point.
Okay. We've gotten a little bit far afield. We're definitely going to have to come back and talk about that diversity, equity, inclusion order. But let's for a moment consider Section 3D of the anti-trans order, which says that State, Homeland Security, and Director of Office of Personnel Management shall implement changes to require that the government-issued identification documents, including passports, visas, and global entry cards, accurately reflect the holder's sex as defined under Section 2 of this order, which in English means that Trump is going to require every executive branch agency to issue federal documents that purposely misgender trans people. And that will get challenged. But if the Supreme Court goes the way we think it will in Skrmetti, those challengers may well lose.
Yeah, and, just to continue your point from earlier, we're about to find out what happens when a trans woman is properly identified as a woman on her state-issued, Real ID-compliant driver's license, but then, because of this executive order, identified as a man on her passport. I mean, brass tacks, the implementation of this from a practical perspective alone is going to be a nightmare, and it's going to put so many people into just horrible positions.
Yeah, and before we leave this, I really do want to talk about one of the most insidious aspects of this, which is Section 4, which is labeled privacy in intimate spaces. And it says the Attorney General and Secretary of Homeland Security shall ensure that males are not detained in women's prisons or housed in women's detention centers. So what they're going to do here is detransition transgender prisoners and then force trans women to go into men's prisons, which puts them in tremendous danger. And it violates a law that passed in 2003 called the Prison Rape Elimination Act. So remember, this is the executive order that was about defending women in their, sacred spaces. But what's going to happen here is that so many of these trans women are going to be forced into men's prisons, which will absolutely and I'm sorry to be brass tacks about this, and I know that I maybe should have included a trigger warning, but these women will be in so much danger of being raped, of sexually assaulted, right? The purpose of this act is to put these women in danger because, as Adam Serwer said so famously, the cruelty is the point. And, look, we've talked about how these laws will be challenged. Obviously, these women who are being, endangered by moving them to men's prisons will have standing to challenge this because it gravely endangers them. It violates their actual rights under the Prison Rape Elimination Act, and it violates other consent decrees. It's like certain states have entered into consent decrees to not put trans women in men's prisons. And other states have laws, right? There are states which have laws about this. So this is going to be another one that is challenged. But I just want to flag it for its really performative cruelty and that it accomplishes the exact opposite, right? There's never been any finding that trans women in women's prisons are a danger to their fellow women prisoners. But there has been absolutely a ton of finding that trans prisoners are at much higher risk of sexual assault and rape. And that's going to be the inevitable result of this. So, all right, that's a bummer. We're going to take another ad break and we will be right back.
And we're back. Okay, let's move on to the executive order attempting to invalidate birthright citizenship. And look, good news. This one is already subject to a temporary restraining order issued Thursday, as we record this, by Judge John Coughenour of the U.S. District Court for the Western District of Washington in Seattle. This is just the first of about 5 cases that are in the pipeline. We'll come to that in a second. But first, I want to kind of parse out the order itself because it's captioned Protecting the Meaning and Value of American Citizenship.
Like it's a stock.
Yeah. It starts with a blatant lie. It says, the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States, but not subject to the jurisdiction thereof. And okay, that part is true-ish. But then here's the sleight of hand. It says, Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of U.S. citizenship does not automatically extend to persons born in the United States, 1, when that person's mother was unlawfully present in the United States and the father was not a United States citizen or a lawful permanent resident at the time of said person's birth, or 2, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as, but not limited to, visiting the United States under the auspices of the Visa Waiver Program or visiting on a student, work, or tourist visa, and the father was not a U.S. citizen or lawful permanent resident. And that part, those two categories are made up out of whole cloth. It has never been true, and U.S. courts have been saying it's not true for 125 years.
Yeah, let me just spell that one out because we've talked about it here before. But subject to the jurisdiction thereof does not mean is a citizen. It doesn't even mean is lawfully present in the United States. It means can the government arrest you if you commit a crime? It means does the law apply to you? And courts have been very clear that there are 2 and only 2 exceptions to this law. I mean, there were 3, but now we all agree that Native Americans are U.S. citizens, even if they are also under tribal law in some circumstances. But today, there are 2 exceptions to the rule. Number 1, if you are a diplomat and you have consular immunity, you're not subject to U.S. law, and your children born here do not automatically get U.S. citizenship. Okay, that makes sense. And number 2, if you are part of a hostile invading army, you are definitionally outside U.S. law, and your children do not get citizenship. Fair. But the point here is that Trump can't just create new categories of people who don't get birthright citizenship. That's not a thing. And Trump is trying to muddy the waters here by pretending that subject to the law means something it doesn't and never has. And a lot of people are falling for that. Like I made a whole video about it on Legal, and 1 million people left not 1 million, but like many people left comments saying that I didn't understand what subject to law meant. I don't think that those people watched the video, but whatever. Like there were also a fair few who said the 14th Amendment was bad and should be changed. And like, okay, fine. People are entitled to their own horrible opinions, but like, don't yell at me, man. Yell at the Supreme Court because the law is what they say it is. The 14th Amendment exists and that ain't on me.
Yeah. So, as we said, as you were correct, Liz, the Trump administration was immediately sued for this blatantly unconstitutional executive order, and Trump's DOJ filed this incredible piece of shit response to the request for a TRO. Here's what Trump's Department of Justice actually argued in court. They said, quote, as a textual matter, the 14th Amendment affords so-called birthright citizenship only to those persons born in the United States and subject to its jurisdiction, and thus excludes children of non-citizens here illegally, as well as children of temporary visa holders. And then the citation for that was to the executive order itself, right? Like, and it makes sense that that was the only citation they could find, because that has not been the law since 1898, which was when the Supreme Court decided U.S. versus Wong Kim Ark. So, like, you can cite to executive orders by Trump or law review articles by John Eastman or whatever, but there are not cases to rely on. So, moving on, the DOJ argues that the states lack standing, which is just, I want a word other than stupid, but stupid. Of course states have standing. Like, the plaintiffs here are the states of Arizona, Illinois, Oregon, and Washington. They're the ones that issue the birth certificates. They have to know who is eligible to receive state benefits for citizens. Like, unbelievably, the Department of Justice lawyers argued that none of that was the government's problem because obviously these babies, and remember, we're talking about babies, they're not citizens. And, you know, if states want to extend benefits to them like they're human beings, that's not Trump's problem.
I hate it. Okay, hang tight. We're going to take one more ad break, and then we're going to get back to Judge Coughenour's order. Is it Coughenour? Is it Coughenour? However I pronounce it, it's going to be wrong, and I apologize, and y'all can yell at us in the comments.
He's a ranking appointee, and, you know, he's been on the bench a long time, but I'm sure he's used to having his name mispronounced.
All right, we're going to be right back. Hang on a sec, guys.
And we're back. Okay. I think from laughing at dumb law, like my favorite part of the DOJ's argument is this passage. So, Liz, see if you can spot. Think of this as a law school issue spotter. Like, identify all of the problems in this passage.
Okay.
The DOJ argues, ample historical evidence shows that the children of non-resident aliens are subject to foreign powers and thus not subject to the jurisdiction of the United States and not constitutionally entitled to birthright citizenship.
Would that be?
For example,
what evidence is that? Okay, go ahead. Give me some evidence.
Dual citizenship, not a thing. Anyway, sorry, I'm giving you a hint here. Back to the brief. For example, before the adoption of the 14th Amendment, Justice Story wrote, persons who are born in a country are generally deemed to be citizens and subjects of that country. A reasonable qualification of the rule would seem to be that it should not apply to the children of parents who were in itinere, and yes, I Googled how to pronounce that Latin, in the country, or were abiding there for temporary purposes as for health or occasional business, and that is from, admittedly, the most famous commentary of the first half of the 19th century, Joseph Story's Commentaries on the Conflict of Laws from 1834.
Wait, is that before 1898? I'm confused. Is that before the adoption of the 14th Amendment? Okay.
Okay. It continues. The Supreme Court's decision in Elk versus Wilkins, 1884, confirms that children of non-resident aliens lack a constitutional right to citizenship. In Elk, the court held that because members of Indian tribes owe immediate allegiance to their tribes, they are not subject to the jurisdiction of the United States and not constitutionally entitled to citizenship. Indian tribes occupy an intermediate position between foreign states and U.S. states. The U.S. connection with the children of illegal aliens and temporary visitors is weaker than its connection with members of Indian tribes. If the latter link is insufficient for birthright citizenship, the former certainly is.
I don't even know where to start. It is so offensive. It's from a practitioner perspective and from an American perspective, totally offensive.
Yeah. Practitioner side, I mean, we flagged most of this already, right? Pre-Civil War, pre-14th Amendment precedents have nothing to do with after they amended the Constitution. And Elk versus Wilkins, okay, that's post-Civil War, but it was decided 14 years before the case that held the exact opposite, Wong Kim Ark, right? Here's the way that I would put it. It would be like writing in a brief today and citing cases from 1890 to 1940 for the proposition that, it's just overreading Brown versus Board of Education to say that schools have to be desegregated.
Yeah, I like the fact that no one in the Trump Justice Department seems to understand that Native Americans are allowed to vote these days. Like, how do you write that the United States connection to Indian tribes is weak and, not die of shame? Like, for the record, Indian Citizenship Act of 1924 extended full citizenship to Native Americans. These are fully Americans.
Yeah.
We do not have a weak connection with them, which allows us to discriminate against everybody else. Like, that's fucking ignorant. I'm sorry for swearing, but seriously.
It's called for. And again, dual sovereignty, dual citizenship, right? Like you
for
can
Native
be
Americans, yeah.
Right. So and for, people with dual Irish and American citizenship, right? Like this is a well-known, the idea that it's like 1834 and you owe allegiance to only one sovereign has not been the law for, more than a century. Anyway, you joked about this, but the government really does accuse the plaintiff states here of overreading Wong Kim Ark, which
overreading. Yeah.
I lack words.
I got a lot of accusations that I overread the birthright citizenship status and Wong Kim Ark. But okay, cutting to the chase.
Don't read the comments, Liz.
Yeah. Judge Coughenour, the esteemed jurist in Seattle, had more or less the same reaction we had to this argument. I'll read a bit from the Seattle Times coverage. He said, "I've been on the bench for over 4 decades. I can't remember another case where the question presented is as clear as this one is. This is a blatantly unconstitutional order. There are other times in world history where we look back and people of goodwill can say, where were the judges? Where were the lawyers?"
He's not saying that the lawyers who filed this thing are Nazis, but he's not saying.
Yeah, so it's going on from the Seattle Times. Coughenour interrupted before Brett Shumate, a Justice Department attorney whose name should live in infamy. Okay, it doesn't say that in the article, but it's true. Yeah. Before Brett Shumate, a Justice Department attorney, could even complete his first sentence. Quote, "In your opinion, is this executive order constitutional?" he asked. Said Shumate, "It absolutely is." Frankly, I have difficulty understanding how a member of the bar could state unequivocally that this is a constitutional order, Coughenour said. It just boggles my mind.
And again, we said this earlier, but it's worth pointing out, Judge Coughenour, Reagan appointee, right? Like, he's not part of the woke left. This is not you and I fulminating about this.
Right.
This is somebody who's been on the bench for 40-odd years from the right.
Yeah. So, okay, as a threshold matter, the court found that, of course, the states have standing. The judge said the order harms the plaintiff states directly by forcing state agencies to lose federal funding and incur substantial costs to provide essential and legally required medical care and social services to resident children subject to the order. Plaintiff states' residents are also irreparably harmed by depriving them of their constitutional right to citizenship and all the associated rights and benefits, including subjecting them to risk of deportation and family separation, depriving them of access to federal funding for medical care and eligibility for basic public benefits that prevent child poverty and promote child health, and impacting their education, employment, and health. Which, no shit, right? I mean, we're talking about kids being born in hospitals who are going to be stateless. Okay, so the court enjoined the government from enforcing Section 2A of the order. That was the, instructive parts. It says, no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship. And the court enjoined Sections 3A and 3B, which order all the cabinet secretaries in the Social Security Administration to comply with the executive order and deny documents and services to babies born here. They have to be denied these documents because they've been uncitizened by executive fiat. Mm-hmm. So this temporary restraining order enjoins enforcement of the executive order nationwide, right? The federal government cannot now refuse to issue a Social Security card to a child born here to non-citizen parents, whether legal or, lawful permanent residents or on student, whatever. If you're here and you're not like, the French ambassador, your kid is a citizen.
Yeah.
But we suspect that the states, particularly states like Texas, will immediately start comply with this order. They're not bound by this order, right? This order only enjoins the federal government from refusing to issue citizenship documents. So I would expect that Texas will almost immediately start issuing or start trying to issue second-class birth certificates to people whose parents can't document their citizenship.
Yeah, I mean, we talked about how Arizona has second-class voting in the state back in October, right? Like, I think that's exactly right, that it's going to be whack-a-mole across the country. And even with respect to the federal government, this is not over, right? Like, we don't get to dust our hands and say, job well done. Like, a TRO, right? The T in that is temporary. Like, so I think Donald Trump is going to proceed on two separate tracks. He's going to seek intermediate interlocutory appellate relief in the Ninth Circuit. It might seek mandamus, right? Like, but there will be multiple filings, probably by the time you're hearing this, that are going to go to the Ninth Circuit. We're probably not going to fare too well in the Ninth Circuit, but that will get teed up immediately to the Supreme Court. And so we haven't seen the last of that. And at the same time, I think he's going to run to one of his pet judges, like maybe, as you've mentioned on the show, Matthew Kaczmarek in the Northern District of Texas, where, he's the only judge sitting in the Amarillo division, and try and get an injunction enjoining this court. And I don't know how any of that is going to work, right? What I do know is that we are far from over in this effort to strip citizenship away from millions of people.
Yeah, I want to just kind of play that one out because we have, in a sense, seen this scenario before. And it was, in fact, Texas and Washington, right? Because in Texas, Judge Kaczmarek enjoined or, he undid the FDA approval for mifepristone. At the same time, a federal judge, a trial judge in Washington, not this trial judge, enjoined the government from taking mifepristone off the shelf, right? And so what you wind up with is these kind of dueling injunctions, and it's such a mess, it gets immediately stayed. But let's talk about this for a second, because I think the goal here is to get before the Supreme Court, right? They knew they were going to get this TRO. Yeah. This is a ridiculous order. It absolutely turns all of 120 years of jurisprudence on its head. It's such a sea change. They knew that it was going to get enjoined, and they don't actually care this time, right? Like they're like, fine, whatever. The game is the Supreme Court, and I am cautiously optimistic. I know we are in this place where we go like laws don't matter and the Supreme Court isn't real and all of that bullshit. And they've certainly earned that from us. But this is so foundational. It seems like one of the things that they would be like, well, you can't do that. I mean, they'll probably let Trump do an absolute insane amount of the horrible, destructive things that he is going to do. But this is one of the ones which I think Chief Justice Roberts would be like, fine, you know what? We're gonna stop this. We'll put a stop to this. We'll let you do, 75% of all of the crazy shit you want to do. And the 25% that we say, no, that's one too many. We'll point to that. It's just sort of as a marker of our own institutional legitimacy.
Yeah, I agree with that, which is pretty bleak. And I want to see that and raise you. We talked about this on the Substack at lawcastpod.com. But
good point.
What the Supreme Court did with respect to the Lemon test, right, of what constitutes an establishment of religion under the First Amendment was kind of a 20-year assault, right? Like it began with, well, Lemon says this, and then, Clarence Thomas would write a pissy dissent. And then the next case would, he would get somebody else to join the dissent. And then the next case would say, well, this is kind of controversial. And it would cite those two cases. And they built up this record of criticizing their own opinions, aided and abetted by right-wing law review articles, until we got to the point in the Bremerton Independent School District case. That was the coach that prayed at the 50-yard line that the Supreme Court lied about. And Justice Sotomayor had to attach photographic evidence that they were lying to her dissent, right?
Right.
Remains incredible to me. But basically what they said was, look, like, how are we supposed to give precedential value to a case like Lemon that's been, such the subject of controversy for so long?
Yeah, I feel a couple of different ways about that. And the first is that, as I said, I think this is so foundational to American identity that I think this will be one which the court will not, it will be a 6-3 decision and maybe even 7-2 in favor of, enjoining this.
Wait, who are the 7? Who are the 2 there?
I think the 2 are possibly Alito and Thomas.
You think they're going to peel off Gorsuch? Interesting. I meant that,
okay, whatever. The point is, I do not think that birthright citizenship is going to go away. I think it's pretty foundational, and it's one of the ones which, the court can kind of do and point to, as I said, to prop up its own institutional legitimacy. But I will say that as a counter to myself, during the 2020 election, John Eastman, the John Eastman, published an article in Newsweek where he put this theory forward that Kamala Harris was ineligible to run for president because she was not subject to the jurisdiction of the United States because her parents were here, I believe, on like student visas or some such. And he was roundly criticized for being racist. And Newsweek had to append, I think, like at least 2 apologies for saying like, oh, we just didn't realize this was going to like encourage all kinds of racist and xenophobic stuff. And that was only 4 years ago, 4.5 years ago. And already the window has moved to where that's basically federal policy. It's stated policy of the Trump administration. And so maybe my belief in the, inviolability of this precedent is misplaced. I hate to end on a sad note. Say something happy.
If I wanted to look on the bright side, I would agree with you that it is so enmeshed in our legal history that it would be radical to upend it. But I think it's significant that, we're thinking it's going to be 6-3 to hold on.
I mean, we thought that, what do we think about the immunity decision? All right, let's not go there. We're just going to.
Bad.
It's bad.
It's real
all right.
bad.
But we're still here. We're all going to hold it together. We're going to hold it together for the next 4 years and beyond. And we're going to get some experts on to talk about these executive orders. And we just got to keep going. You got to hold hands and you got to keep marching.
Hear, hear.
All right. That's going to do it for us, guys. Have as good a weekend as you can. And we'll talk to you soon.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.
Shopify's point-of-sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.